Thank you for attending this session. My name is Tonge, and with my colleagues Julie Morrish and Elise Neilson from UQ's Legal Services Division, we would like to give you an introduction to Australia's Foreign Relations, State and Territory Arrangements Act 2020 and its associated Foreign Arrangement Disclosure Scheme. I'll start by discussing the background to the Act, its objectives and the key concepts behind the Act. Julie and Elise will take us through several worked examples of where the Act might apply, the notification procedures under the Act and the Minister's powers, and finally we'll discuss some currently available resources which might be of assistance to you. How did all this start? The next slide gives us some explanation. 2020 was an extraordinary year. The world as we knew it changed before our very eyes. Long-established alliances became shaky and previously friendly countries became not so friendly. Even in Australia itself, the traditional relationship and trust between the states themselves and the state's relationship with the Commonwealth changed forever, exacerbated in no small way by the imposition of hard borders and the perceived failure of certain states in their battle against COVID. The Act was fast and furious. It was first mooted in August 2020, introduced into Parliament in September. There was a Senate committee hearing on it, in which there were numerous submissions made by including Universities Australia and the Law Council. Then the Act went to the Senate and was passed in early December and commenced on the 10th of December. So it was a 3-month passage, very quick. Critical dates for UQ are coming up in March and June. The March date, which is the 10th of March, is when UQ is expected to report, or is required to report, all future foreign arrangements. The June date, June the 10th, is the date by which UQ must notify DFAT of all its pre-existing foreign arrangements. As you can guess, there's going to be significant strategic, legal and compliance issues for the university. What are the objects to the Act? It's really important that we look at these carefully. The purpose of it was stated to be to avoid what was described as a blind spot. The Commonwealth knew perfectly well what its overseas negotiations were. It has foreign approvals for companies so that purchases of land by foreigners can be caught and regulated. But the blind spot, as far as the Commonwealth was concerned, was the state territory entities and their negotiations with foreign governments and universities. So we could read that fairly carefully. The object of the Act is to ensure that the Commonwealth is able to protect and manage Australia's foreign relations by ensuring arrangements between a state territory entity and a foreign entity do not and are unlikely to adversely affect Australia's foreign relations and do not and or are unlikely to be inconsistent with Australia's foreign policy. Now, these phrases, foreign relations and foreign policy, are used throughout the Act and are often used as the trigger for a minister's actions. Foreign relations is not defined, but foreign policy is. So what's Australia's foreign policy? It's a fluid concept, and the best we can get is the definition which provides that Australia's foreign policy includes policy that the Minister is satisfied is the Commonwealth's policy on matters that relate to Australia's foreign relations or things outside Australia, whether or not the policy is written or publicly available or has been formulated, decided upon or approved by any member or body of the Commonwealth. Importantly, there's 2 things to pick up from this. One is that policy changes. Now, I think you'd agree that Australia's policy with respect to Myanmar would certainly have changed considerably over the past 3 months. Secondly, it's not just DFAT. DFAT is the body we think of as Foreign Affairs and Trade making Australian policy, but effectively it's any part of the Commonwealth that can make foreign policy. So it may be the Minister for Communications, the Minister for Education and so on, or Minister for Health, who decides what Australia's foreign policy is with respect to their controlled areas. Okay, so in a nutshell, what are we looking for? It's very little to be gained from second guessing what policy is. We don't just say, well, we think we know what the policy is and we'll enter into agreements in compliance with that. The best thing we can do is to just identify all foreign arrangements, existing or prospective. A foreign arrangement is an arrangement between a state territory entity and a foreign entity, whether or not other entities are also a party to the arrangement. Now, this is important, that there may be agreements where UQ is a party with, say, CSIRO or with the state government with respect to overseas arrangements. Importantly, our concern is if UQ is a party, it's a foreign arrangement as far as we're concerned, and the disclosure and issues arise from that. Let's go through the key concepts. The first one is state territory entity. Now, this is perhaps the best and the easiest one for us to look at. Obviously, it's directed at the state governments, state government departments, agencies, and also local authorities such as the Brisbane City Council. However, the jig is up for the University of Queensland. It is a state territory entity without doubt, because it is a university established by a law of a state and accordingly is caught as a state territory entity. Now, importantly, there's one carve-out in the definition of state territory entity, which is of relevance. It's that corporations that operate on a commercial basis and hospitals are expressly excluded from the definition. So as far as UQ is concerned, its controlled entities such as UniQuest, JK Tech, UQ Sport and UQ Healthcare are not captured as state territory entities. So an agreement between JK Tech and a foreign government would not be a foreign arrangement. However, we're not totally out of jail free. Arrangements between these controlled entities may, however, be what's called subsidiary arrangements, and we'll talk about those more later in this session. But effectively, although the UQ's controlled companies won't be captured as a foreign arrangement, there may be some relevance as a possible subsidiary arrangement. The harder concept is what's a foreign entity. Now, if I could go through the list, a foreign entity is either a foreign country, a national government of a foreign country, a department or agency of a foreign country or government, a province, state, self-governing territory, region, local council, municipality or other political subdivision of a foreign country. So they're all pretty easy to understand. An entity other than a university, which is an authority of a foreign country established for a public purpose, or, most importantly for UQ and perhaps the one with most difficulty, a foreign university that does not have institutional autonomy. Similar to the state territory entity carve-out, we have, as a carve-out from the foreign entity definition, corporations operating on a commercial basis, and they're excluded. Okay, let's look at this concept of institutional autonomy. How do we determine this? A university does not have institutional autonomy if and only if, by virtue of a law or the university's governing documents. Firstly, a majority of the members of the university's governing body are required to be members or part of the political party that forms the foreign government, or education provided or research conducted at the university is required to adhere to or be in service of political principles or political doctrines of the foreign country, or the political party that forms the foreign government, or the university's academic staff are required to adhere to or be in service of political principles or political doctrines of the foreign government or the political party that forms the foreign government in their teaching, research, discussions, publications or public commentary. So it's any one of those three. And you may say, well, they're pretty tough and they're unlikely to occur except in totalitarian government. But how do we know? The DFAT provides no assistance at all. The best we get is in one of its fact sheets. DFAT says that the Russell Group, which is the UK top universities, including Oxford and Cambridge, DFAT suggests that they won't be caught, but that assurance isn't even passed into legislation. So really, we can think something doesn't have an institutional autonomy, but it's a question for each university to ascertain, for us to ascertain, whether or not it does have institutional autonomy. So how do you find out? Well, you look at the university's governing documents or the law. The university's governing documents are the constitution, rules or other documents by which the university is constituted or according to which the university operates. So if we were doing a due diligence on, say, the University of Queensland, we'd be looking at the Founding Act, the University of Queensland Act, and also at the policies and procedures. Now, there's a fair bundle of documents there, and luckily they'll be in English. So when we're dealing with a foreign university, you need to make sure that you're looking at the governing documents and, if necessary, have it all translated into English. It's not an easy task. Okay, the final concept I need to speak about is arrangement. An arrangement is any written arrangement, agreement, contract, understanding or undertaking, irrespective of whether it's legally binding or where and when it is made. Now, so this will obviously cover contracts such as contracts, agreements, memorandum of understandings, exchange of emails between universities, and even minutes of meetings if both parties have been at a meeting and the record of the meeting is put down in writing as the minutes of meeting. There are a couple of exemptions. Minor variations of previously notified foreign arrangements are exempted, and arrangements regarding administrative matters only, such as flights, accommodation and submitting visas and so on, are expressly excluded as a foreign arrangement. The Department DFAT has provided some assistance with respect to grant applications. Grant applications are not notifiable as a foreign arrangement until both parties have committed to progress the grant arrangement. Now I'll hand over to Elise and Julie.
Hi everyone. Now that we've fleshed out the key AFRA terminology and concepts, let's visit what we're actually applying these concepts to on the ground in practice. So we're looking for foreign arrangements, and we'll turn in a moment to what we do with those once we identify them. But a foreign arrangement is an arrangement between a state, territory entity and a foreign entity, whether or not there are also other parties to that arrangement. So we know the term arrangement is broad, we know UQ is court, so in practice, our real focus is on identifying the foreign entity. That means focusing on the foreign parties and partners we are dealing with. Remember, for UQ's purposes, the parties to the arrangement are key rather than the activity. With this in mind, we think it would be helpful to walk you through UQ's AFRA flowchart. For later reference, you can also find it on the Legal Services website. It's at the end of our AFRA fact sheet. So let's have a look at some UQ-inspired scenarios to show how you will need to work through to identify UQ's foreign arrangements for AFRA purposes.
Thanks, Elise. Let's run through our first scenario on the next slide about Sing Health. Sing Health is responsible for and oversees a cluster of hospitals and clinics providing healthcare services in Singapore. Singapore Hospital, operated by Sing Health, is known for delivering an outstanding practical clinical training experience for nursing and midwifery students. UQ has requested that Sing Health facilitate the placement of 10 final year nursing students at Singapore Hospital later in the year in semester 2. UQ and Sing Health sign a deed setting out the intention to place UQ students at Singapore Hospital subject to the hospital's operational requirements. So the question is, do we think that AFRA applies here? Well, let's have a look at our flowchart. What we should do is work through the flowchart from the top, and we know that the first question to consider is who is the party that UQ is dealing with. Now, if we have a look in the top box, let's consider if we have come across any of these types of entities in our scenario. Look, obviously it's going to take some due diligence to get up to speed with the nature of the healthcare system in Singapore, but based on the information we have, looking at our flowchart, it seems plausible to me we could have either possibly a department or an agency of the foreign government, which is the third dot point on our flowchart, or also possibly the fifth entity, which is an authority of a foreign entity or government established for a public purpose. So I think that's really akin to perhaps the way Queensland Health and the state government operate. So assuming we're going to answer yes to that first question in our top box, following our flowchart, that would take us down to the second question. Is UQ dealing with a corporation that operates on a commercial basis? Based on our scenario, there's nothing obvious to me in the scenario that we could answer yes to that question. So we would flow down to the next question, which is about a written arrangement. Do we think, based on our scenario facts, that we are dealing with an arrangement in writing? Well, we know that the arrangement is a deed in this case. It's signed by the parties, so that's a definite yes to that question. And that makes us flow down to our final question in the flowchart. And it seems to me that this is not a minor administrative matter or perhaps a variation to an arrangement. So I think the assessment we'd be making, based on the scenario facts we've received, is that AFRA would apply to our Sing Health scenario.
Thanks, Julie. Now we're going to take a look at another scenario. It's about Tonge University in China. Tonge University is a leading public university in China with an extensive university museum collection. UQ is interested in opportunities for collaboration with XJTU in art history, including supporting student mobility. UQ and XJTU sign an international cooperation agreement to explore collaboration opportunities. The agreement is non-exclusive and both parties are free to enter agreements with other parties. Does AFRA apply? Well, let's have a look at our flowchart. The top box is all about the foreign country, its government departments. We're not in this box, are we? We're talking about a foreign university, XJTU. Stephen talked earlier about the 3-point test for institutional autonomy, or a lack thereof. For a foreign university to lack institutional autonomy, it needs to meet just one of these 3 criteria. To paraphrase, the tests are essentially around 1, membership of the university's governing body being linked to the national political party or government. 2, education or research having to adhere to political doctrines. Or 3, academic staff having to adhere to political doctrines in their teaching or research activities. In applying this 3-pronged test for institutional autonomy, we are only required to take into account official documents rather than things like custom, observation, trends, and things like that. So what we would be examining would be the university's governing documents, which could include things like its constitution, a statute establishing or otherwise guiding the university strategy or operations, rules, regulations, or policies and procedures of the university, as Stephen touched on. So it's fine to say these are the kinds of documents you should be considering, but it is a separate question as to how you'll know which types of documents you'll be looking at for your particular institution, and whether you'll be able to readily get your hands on them. Not to mention, in many cases, they will be in a language other than English, as would be the case for XJTU. So it's going to be difficult and tedious in many cases, but it's a due diligence exercise in order to make an educated assessment about the institutional autonomy. And UQ is working on its approach to this particular due diligence exercise. Ultimately, if your due diligence on the institutional autonomy point does not show any of these hallmarks of a lack of institutional autonomy, and of course if you're not dealing with any of the entities we touched on in that top box at the top of the flowchart, the result is that AFRA would not apply. If the foreign university you're looking at satisfies any one of these lack of institutional autonomy tests, you would be caught by AFRA. So let's assume that we think that we are in the case of XJTU and move down to the next box. Is UQ dealing with a corporation that operates on a commercial basis? There's nothing in the scenario to suggest that. This is a national university, so no. We then look at whether there's a written arrangement. There clearly is. The parties have signed an agreement, and none of those minor matters actually apply in relation to this. So in this scenario, AFRA would apply. The other thing that I'd take from this scenario is we're talking about a collaboration in student mobility in art history to access the museum collection. This isn't something that you might automatically think is a worry because it's going to impact on Australia's foreign relations, but remember that's not what we're looking at when we're conducting this test for UQ. We're just trying to identify the foreign arrangements, and the subject matter of those arrangements doesn't really matter, it's the parties.
Thanks, Elise. Let's move on to our third scenario, Chinaway. Chinaway Limited is a telecommunications equipment supplier with a global presence. Chinaway is a company listed for trading at the Shanghai Stock Exchange. UQ through it wishes to participate in a research program with Chinaway. The parties intend to collaborate to deliver technical solutions to a range of mobile phone hardware issues. UQ and Chinaway negotiate and then sign a 3-year research collaboration agreement. Do we think that AFRA applies in this situation? Well, now that we're all becoming a little bit more familiar with using our flowchart, I think the key piece of information that really stands out for me in this scenario is that we're dealing with a company listed on the stock exchange. So it almost feels like we could jump straight to the middle of our flowchart down to the question, is UQ dealing with a corporation operating on a commercial basis? And if the answer to that is yes, which based on our scenario, I think we could say, we are straight into the assessment that AFRA would not apply here, which may be surprising to some, but I think based on our facts, that's the assessment we would be making about Chinaway Limited and UQ's arrangement.
Thanks, Julie. And we've got one final scenario to take you through. This is involving UQ Professor Ian Smith, who's an expert in biomedical engineering. He regularly participates in research collaborations with his colleagues at Ho Chi Minh City International University. Ho Chi Minh has offered Professor Smith an honorary professorial appointment. Ho Chi Minh has issued a letter to Professor Smith in relation to this appointment, and Professor Smith has accepted the position by countersigning the letter. You know, one of those panels at the bottom of the letter where you indicate that you agree. Does AFRA apply? Now, if we have a look at your flowchart, you'll see right at the top, the question we're asking is UQ dealing with the party that? Now, in this case, this is an honorary appointment. It is likely to be addressed to Professor Smith as an individual. Ho Chi Minh City International University is offering this position to Professor Smith the man, not to UQ as an institution. So in that case, and provided that everything about the letter reflected that it was an agreement with Professor Smith as an individual, AFRA would not apply. Of course, this is a line ball kind of a test because it would very much depend on the terms of the specific letter. So you need to check in each case. But in the example that we're using, it's not UQ that's doing the dealing, it's an individual, so it's outside AFRA.
So look, after our 4 scenarios and mastering the use of the flowchart via our scenarios, if you do have a foreign arrangement that you feel is caught by AFRA, what now? That's the question. What do we do next? Well, the first implication of an arrangement being caught by AFRA is it triggers APRA's really comprehensive notification regime. And there's 2 aspects that we need to walk you through. First, UQ will be required to identify all of its current and existing foreign arrangements, and we need to report them to the Minister by the 9th of June this year. So we need to be aware reporting for this tranche of agreements there's no date range. If you've got an arrangement that's on foot, no matter how old it is, if it hasn't been terminated or expires, so this could go back to the 80s or 90s, they will be caught and we will have to notify. So on its face, it's a huge task for the university. In addition though, secondly, from the 10th of March, UQ is also required to notify to the Minister any prospective foreign arrangements. And there's 2 limbs to this notification requirement. Notifications are required both of UQ's proposal to enter the arrangement, so that's really before the arrangement is signed or otherwise finalised. And then we need to notify again a second time within 14 days once the arrangement has actually been entered. That is, it's been fully signed or otherwise authorised. So now that we've looked at when UQ will be required to notify the Minister of Foreign Arrangements, the next question is, well, how do we go about doing this?
Thanks, Julie. So as to the how of notification, this is essentially a manual entry online process through a special DFAT foreign arrangements portal. There's no bulk uploads via spreadsheet or anything like that. DFAT's made it clear to us. Notification must be done one at a time. As part of UQ's compliance piece, UQ will determine who does the uploading to the portal for UQ. There's a bunch of information you need to provide, and notably a copy of the arrangement itself. A high-level subset of this information will be included on an online public register. Importantly though, the actual copy of the arrangement will not be accessible on the register. Also, you can request certain details be excluded from the register for commercial in confidence and legal privilege reasons. So, for example, if you felt there was a confidential aspect to even the title of the arrangement, you could ask for that to be redacted on the register. To give you a feel, here's a snapshot from the register. Note we have China, US and Israel agreements there and a broad range of dates for longevity of these agreements. You'll see the couple there date back to the 80s. In case you're wondering, at last check there were no university entries yet.
Excellent. So ultimately what we're looking at is a massive compliance activity for the university. Clearly there's a lot of work that has to come next. We've talked through the fact that we're going to be looking through existing foreign arrangements, of which we expect UQ will have quite a number that at least need to be considered in some detail and some that will actually need to be notified. In addition, we know that UQ is going to have to construct a whole compliance regime moving forward in order to capture the two-stage process of notifying proposals to enter a foreign arrangement and then the actual entry to the foreign arrangement. The reality is, from our perspective, there seems no quick shortcut to either of these aspects of compliance. It's largely a manual task and a massive challenge in an institution like this one, with so many records in different categories, retained not only centrally, but within local organisational units across the university.
That's right. So we've talked about the key concepts, we've worked through our scenarios and worked out how we identify foreign arrangements that have to be captured by AFRA. And we've looked at the large compliance exercise that AFRA brings. So substantively, what's next? What is the point of it all? Remember, the object of this AFRA legislation was essentially to give the Commonwealth the power to safeguard against foreign arrangements that may adversely affect Australia's foreign relations. This means the Minister is given really broad powers to call off or strike down these foreign arrangements. And the Minister can do this by issuing a declaration directing UQ to vary or terminate an arrangement, or a declaration deeming the arrangement to be unenforceable or invalid altogether. The Minister may also make a declaration precluding the university from continuing negotiations on entering into a foreign arrangement. This is really significant from a legal perspective, since the Commonwealth doesn't even need to be a party to such an arrangement. They're a third party coming in and unilaterally deciding the fate of the arrangement. It doesn't matter if any of the parties to the arrangement disagree, or if they would be significantly disadvantaged or aggrieved by the decision.
So in practice, from UQ's perspective, it could be extremely messy at best, and frankly there could be significant negative impacts on our relationships and reputation at worst if a declaration was to be made by the Minister. And one thing we need to note at this point is that the Minister can make a declaration in respect of a foreign arrangement as defined by AFRA, regardless of whether that arrangement was actually notified as part of the compliance regime that we've just talked through. So one of the key risk mitigation strategies that we'll be putting into place will be to include new clauses in UQ's agreements, including in our template agreements, allowing UQ under the agreement to take whatever steps we need to do in order to comply with the Minister's declaration.
But wait, there's more. Just when we've digested the types of declarations that the Minister can make in relation to foreign arrangements, the net is actually even wider, because AFRA also includes this concept of subsidiary arrangements. These are arrangements that are not foreign arrangements in themselves, but are entered into under the auspices of the foreign arrangement. Basically, they're contemplated by or are implementing the foreign arrangement. No, UQ doesn't even need to be a party to a subsidiary arrangement. It just needs to be one contemplated by or implementing the foreign arrangement to which UQ would be a party to. The Minister's powers to make declarations affecting foreign arrangements on foot are mirrored for these subsidiary arrangements.
So for example, if UQ was a party to a centre agreement with a foreign entity and the centre was physically located in Queen Street in the city, the lease supporting this arrangement would be a subsidiary arrangement. You can see from an example like this that it may be even more difficult to identify these arrangements because they're that step removed from the foreign entity concept. So essentially, what we think UQ is going to have to do is to go ahead and identify the foreign arrangement and then think about what potential arrangements could hang off from there. And quite often we know that that will involve different UQ internal organisational units. And again, this is certainly going to be a challenge for UQ.
Indeed, thanks Julie. So what is UQ doing about the AFRA regime, bearing in mind the upcoming timeframes for compliance on 10 March and 9 June? The Provost is leading a task force that's been established to tackle AFRA from a compliance perspective. On the next slide, we've also included some really useful references, both within UQ and via DFAT, for reference in your AFRA travels. This ends our presentation. Thank you very much, everyone. Thank you.